I will jump right into my presentation. Thank you so much for the introduction. I'm happy to be joining you today to be discussing the two MOUs that we are managing here at the European Commission at DG Grow, focusing on intellectual property rights. So you'll see I will start by talking about the MOU on the sale of counterfeit goods on the internet. Which was signed in 2011 with the objective of preventing offers of counterfeit goods from appearing on online marketplaces. And then I will move on to the MOU on online advertising and intellectual property rights, which was first discussed in 2016 and then signed in 2018 with the objective of limiting advertising on websites and mobile applications that infringe copyright or disseminate counterfeit goods. We tend to refer to them informally as the MOU on counterfeiting and the MOU on advertising, which I understand can at times be a little bit confusing since they're both MOU, but if there's anything that's unclear, please feel free to ask a question. So as I said, I will start with the MOU on the sale of counterfeit goods online. And I will start by giving you a little bit of background to see where this comes from. This MOU was first signed in 2011 when we identified a trend of counterfeit activities moving from the offline world into online marketplaces as e-commerce was also growing. The objective was to counter this trend and to have a coordinated action between the different relevant players so that we could have some positive effect. This is a voluntary industry-led agreement, which is facilitated by the European Commission. And at first, in 2011, it was a simpler agreement than it is now. It already had a group of principles to which the signatories agreed. But then in 2016, the MOU was renewed and signed again by the signatories. And it was in 2016 that it became a bit more robust by including not only a list of rules and the idea of regular cooperation in good faith, but also a regular monitoring exercise of key performance indicators, KPIs, which happens twice per year. And this exercise allows the signatories to keep track of the impact of the cooperation under the MOU, and thus makes it a bit more tangible. As you can see, there are several key areas covered in this MOU, which, if you read through the text of the MOU, you can clearly see that although it's not legally binding to the signatories, it establishes certain standards for both right holders and platforms, which are the basis of their understanding and the basis of the cooperation. And these principles include many different things, but here you can see listed some of them, which are the use of proactive and preventive measures, notice and takedown procedures, policies against repeat infringers, the boosting of cooperation, including sharing of useful information back and forth between the signatories, focusing on boosting also consumer confidence, information, and protection, because at the end of the day, counterfeiting is a consumer issue, and it's important that consumers are involved. And also cooperation with customs and other law enforcement authorities. So I will now move on to the MOU cooperation in practice, which I think is perhaps the most interesting part of the presentation, as with this kind of initiative, the value added from the initiative really comes from the practice. So at the moment, we have 35 signatories of the MOU on counterfeiting. And this list includes 16 right holders, 11 online platforms, and 8 industry associations. In addition to this, here, the team at DG Grow that manages the MOU, we are always in contact with other potential signatories who may be interested in joining the cooperation. So this is not a set list, but rather something that is always evolving with time. The last signatory to join the MOU was Vestiaire Collective, the online secondhand platform, and they joined just earlier this year. So this is always moving. And the way I like to see it, there are three main aspects to the participation in the MOU in practice. The first one relates a bit to the previous slide and the list of principles covered by the MOU. And this is when signatories join the MOU, they adopt and adhere to the principles that are there enshrined. The second element is the collective discussion among all the signatories of the MOU. The signatories usually meet twice per year in a general meeting where they have discussions on the experience that they have with the MOU cooperation, agreements and disagreements, the challenges that they have faced and how they overcame those challenges, both in terms of engaging with the other signatories, but also more broadly, the challenges they face in terms of identifying and fighting counterfeiting. Also, the opportunities afforded by new technologies such as AI, and the experiences of the signatories cooperating with law enforcement authorities. So as you can see, this is quite a few different topics and they tend to come up more or less in every meeting. And in addition to the general meetings, sometimes there can also be other more specific targeted meetings if there's a topic that warrants it. Lastly, I'll also mention that it is within this context of the collective discussion in the general meetings that we discuss the results of the data collection analysis of the KPIs that I was mentioning before. But I will get more into that in a couple of slides. Now, the third and last element that I would like to highlight from the MOU cooperation in practice is the bilateral cooperation between the signatories. And I want to really highlight the fact that this is not a minor element of the cooperation, but rather something that's very important. The main purpose of the MOU is to create a safe space where signatories can trust each other and work together to fight counterfeiting. And as such, they are very much encouraged to go beyond the collective discussion and to connect with each other bilaterally and take advantage of the goodwill that is built through the MOU to act on practical and strategic issues. And this is really also an essential part of the MOU participation, so much so that when given the chance to provide feedback on the MOU, it is very often the case that the signatories will highlight this opportunity for bilateral exchange as precisely one of the biggest added values that the cooperation brings. So, next slide, please. Yeah. To clarify a little bit the role of the European Commission as well as the UIPO in relation to this MOU and vis-a-vis the signatories, it's important to highlight that neither the Commission nor the UIPO are signatories to the agreement. The Commission plays a facilitating role by organizing the general meetings twice per year, ensuring that all the signatories act constructively and in good faith, promoting the cooperation under the MOU, and explaining the functioning and benefits of the MOU to potential new signatories, reaching out beyond the current signatories so we can keep the MOU as alive as possible. Similarly, the UIPO, which is the EU Intellectual Property Office, is not a signatory, but acts as a trusted party for the signatories, especially when it comes to the data collection of the KPIs. Because being a trusted third party, they can ensure the confidentiality of individual submissions so that signatories can feel protected when providing confidential information. They ensure a neutral, non-discriminatory evaluation process for the data collection. They perform aggregating and analysis, and then they send the results to us, to the European Commission, in a manner which is anonymous. So signatories only need to share the information with each other or even with the Commission if they want to. They can, and oftentimes they do share the results directly with us so we can be aware of what's going on. But in principle, the UIPO can serve as this trusted party and a bit of a barrier to make sure that information remains confidential. Next slide, please. So now going a bit more into the data collection exercise specifically. As I mentioned, this was a new element that was introduced in the MoU cooperation in 2016, the KPIs. Twice a year, there is a data collection exercise with a specific framework to help signatories structure their own monitoring process, so that it's a bit of a formalistic exercise, so we can take conclusions about the number of counterfeits found and other KPIs throughout time, and we can analyze and compare it. Those KPIs focus on a number of product categories, namely luxury brands, sporting goods, fashion brands, fast-moving consumer goods, and electronics. There are 3 different KPIs which the signatories may collect. KPI 1 is more focused on the right holders, and it measures the number of offers of alleged counterfeit goods on a platform. KPI 2 and 3 are more focused on the platforms, and the KPI 2 refers to the number of listings removed because of an alleged infringement of a signatory's IP rights, and KPI 3 measures the number of permanent and temporary seller restrictions imposed by online platforms for the alleged infringements of IP rights. As I mentioned, after the data collection, which happens twice a year, the right holders and platforms discuss the results bilaterally. They agree on the results, they send them to the UIPO to be aggregated and analyzed, and then they are discussed in a general meeting already in a confidential form. Next slide, please. So this analysis allows us to see some interesting trends. So as you can see in the presentation, the data collection allows us to assess the percentage of counterfeit goods identified per exercise and also per product category, where you can see interesting evolution throughout time. For example, when it comes to luxury brands, we can see that there has been a decrease. Whereas when it comes to sporting goods, for example, there isn't as clear a trend over the last few years. And it's interesting to reflect on this throughout time. Next slide. And on this slide, you can see how the number of seller restrictions imposed by the online platforms has generally increased over the last decade, both in terms of the total number of seller restrictions applied, but also specifically the number of seller restrictions applied, which are linked to the brands that are signatories to the MoU. So next slide. Moving on to the key outcomes of the MoU on counterfeiting. The European Commission has regularly published a report on the functioning of the MoU, and we also received informal feedback from the signatories on a rolling basis throughout the years. In general, a positive impact has been observed. And this includes a reduction in counterfeit listings, which is supported by the KPI tracking, an enhanced collaboration with customs and law enforcement for identifying high-risk sellers and counterfeit networks so that then they can be addressed in appropriate ways. The development of proactive measures like identity verification, which is again and again mentioned by the signatories as one of the most important elements of the cooperation, proactive detection of counterfeit items, and brand protection programs, which, if we think back to 2011, wasn't such a common thing for platforms to have robust brand protection programs, whereas now it is much more common, and we can see that awareness is at a completely different level. And also, we received the feedback that both right holders and online platforms value the regular meetings and the opportunity to exchange, to share insights, challenges, and best practices, and to develop this closer relationship that in the end helps them be more effective. So in short, the MoU works a little bit as a lab of good practices. It is a good and flexible platform where signatures can discuss the challenges that they face and the solutions that they have found. They can share them with each other and influence each other to ultimately achieve better results from this exchange, and get to the most efficient solutions. Next slide, please. So, as I mentioned before, and as you can see, the last time that the MOU was reviewed and changed was in 2016, which was already a while ago, 8 years. So now we at DG Grow, together with the signatories of the MOU, are reflecting on a potential modernization of this MOU with the objective of keeping it up to date and ensuring that it remains useful, particularly taking it into account that there have been massive changes within the last few years, and the changes relate to, first of all, the legislative framework in the EU. Most recently, we have the Digital Services Act, which changes the legal framework on which these right holders and platforms are operating. But also new technologies which have become more and more common, which offer, for example, such as AI. They have the potential to offer both challenges and solutions, and it's certainly interesting to reflect this in the MOU. And also the counterfeiting practices themselves, which have evolved a lot throughout the last few years. So yes, that is all on the MOU on counterfeiting. Again, if you have any questions, please feel free to ask them. I will now move on to the MOU on online advertising and IP rights. This MOU was born from the identification of a quite specific problem, which is the placement of legitimate advertising on websites and mobile apps which sell or promote IP infringing content or products, counterfeits. The misplacement of these ads is a serious issue because it creates confusion in the consumer. You see, when a user goes onto a website which is promoting illegal content, counterfeit goods, or copyright infringing content, and they see legitimate advertising from brands which they know well and trust on this website, this can create confusion. And the consumer may mistakenly believe that such websites or apps are actually providing access to legal content, goods, and services. And ultimately, this can lead to an erosion of consumer trust once the consumer becomes aware that this website is actually not legitimate at all. It can damage the reputation of the legitimate brand, which by accident has their advertising on this website. And also it damages the reputation of the advertising industry in itself, because in general, just it has an effect on confidence. The situation is that we identified is that brands themselves were often unaware of the fact that their ads could be ending up in these illegal websites. And therefore they were unaware of this problem. They were unaware of the fact that their ads were ending up on these websites, and this created issues. Even in addition to this, we have also seen that websites and mobile applications that provide access to IP infringing content, goods, or services on a commercial scale use the sale of advertising space as one of their revenue sources by misusing the online advertising model. So not only did it have the danger of creating confusion and being quite damaging towards the reputation of the different players involved, also it provided a revenue stream for illegal activities. On the other hand, IP infringement is a serious issue because it reduces economic growth, damages competitiveness, and hinders job creation. It also harms consumers. It also harms consumers' safety. It harms companies because they lose revenue, and ultimately society as a whole, due to losses in tax revenues and just the potential danger of this type of content. And so, having identified this problem, in March 2016, the Commission held a Stakeholders-General meeting on online advertising and IP rights, bringing all the interested parties together. And this includes the advertising industry, intermediaries, the content protection sector, online media, right holders, civil society, consumer organizations, brands, and advertisings. And all of these stakeholders discussed the possibility of establishing a voluntary agreement at EU level in order to avoid the misplacement of advertising on IP infringing websites, and thereby restricting the flow of revenue to such sites, whilst also safeguarding the reputation of the advertisers and the integrity of the advertising industry. At the next meeting, still in 2016, the signatories agreed on the basic principles of an agreement, which ultimately was signed in 2018. So I'll now move on to the key areas covered by this MoU, the MoU on advertising. And these are the proactive measures against IP infringement in advertising, transparency and accountability in advertising practices, ad placement policies to avoid infringing content, an effort to strengthen cooperation among stakeholders and continuously raise awareness about this issue, as well as monitoring and reporting on MoU effectiveness so it can continue to be useful and remain alive throughout time. Next slide, please. The one before. Yeah. So going to the MoU cooperation in practice, this MoU was signed in 2018, as it has continued to grow ever since. At the moment, there are 31 signatories, which include advertisers, advertising intermediaries, and industry associations. And all of these signatories, when they sign the MoU, make a commitment to each other to follow a series of principles which are in the MoU text itself and which are worth highlighting. First of all, there's a commitment by advertisers to undertake reasonable measures to prevent and minimize the placement of their advertising on infringing websites. Second, there's a commitment by advertisers to develop, adopt, and make publicly available an IPR policy, which includes information on the measures, tools, and safeguards which they put in place to prevent these problems. Thirdly, there's commitments by advertising intermediaries to include safeguards against IPR infringements within their contractual agreement, so when doing business to protect IPRs. And then lastly, a commitment by all of the signatories to continuously cooperate in good spirit and good faith to ultimately achieve the goal of improving the situation and preventing this problem. The most visible element of the cooperation under the MoU, much like the MoU on counterfeiting, is the organization of general meetings, which typically happen twice a year. They bring all the signatories together and they give them an opportunity to discuss common topics, such as new trends and challenges in the enforcement of IP rights, as well as solutions and good practices that they put in place to overcome those challenges. Also, their experiences and opinions about the usefulness and effectiveness of the cooperation under the MoU itself, so we can continue to reflect on this, and also the opportunities afforded by new technologies to effectively fight IP infringement and prevent IP infringers from taking advantage of legitimate advertising to fund their illegal activities. So, next slide, please. You can see here, unfortunately, that there has been, over the last few years, an increase of ad views on illegal websites when compared to high-risk websites from 2021 to 2024. You can also, and in the next slide, you can also see exactly that there's also an increase of views on illegal apps, and particularly when it comes to illegal apps when compared to websites, this is a significant trend which we have identified over the last few years. Next slide, please. So now moving on to the key outcomes of the MOU on advertising, there is also a positive impact observed with a 12% reduction in average ads per visit to IP infringing websites. There is also a decrease in gambling ads from major brands on infringing websites, as well as an overall reduction in EU brand presence on IP infringing websites. As I was mentioning before, this is really a problem which, at least it starts by raising awareness, right? Because if these EU brands are unaware that their advertising, that their ads are ending up in these illegal websites, well, then really it's impossible to solve the problem. So that's where it all starts, and it's quite interesting to see that there has been a result. And also, much like the MOU on counterfeiting, the MOU on advertising provides a good opportunity to exchange on good practices and tools that can make this fight a little bit easier. For example, the use of exclusion lists, brand safety policies, and third-party verification by signatories, as well as improved collaboration across the advertising supply chain to prevent ad misplacement. So, this is the end of my presentation. I would like to thank you very much for listening to this, and I look forward to the discussion.